And so, hello, everyone, and officially welcome to What Employers Should Know About the Updated Form I-9, an NJBIA HR program brought to you by Connell Foley, Association Member Trust, Focus New Jersey, New Jersey Business Magazine, the NJBIA HR Support Center, and Prime Point HRMS Payroll. I'm Kate Conrad. I serve as the Vice President of Strategic Partnerships with NJBIA. And with us today are Neil Dornbaum and Kathleen Paraguay of Connell Foley. For those of you who are new to NJBIA, we are the largest statewide business association in the country, representing approximately 1 million jobs in the state of New Jersey, which amounts to about 1/4 of New Jersey's workforce. We offer customer development opportunities, visibility through events, magazine ads, or our podcast and TV shows, and money-saving discounts on stuff you're probably already paying for, like payroll, healthcare, a 401k solution, and our new HR support center powered by Mineral HR. Before we get started, we're going to show you a quick video on some of the new services BIA has been working on for you. You may have received an email from Mineral HR, NJBIA's HR partner, to log into the new and improved NJBIA HR Support Center, where you can find up-to-date employment laws, sample HR documents, and training videos. Our new HR Essentials combines the on-demand HR support with over 30 digital training courses for your staff, including workplace harassment prevention. Danielle, take it away.
Your business is your passion, but running it gets harder every day. Because laws change and compliance tasks change. So many questions, so many answers, so many tools, so many documents, all over the place. Am I doing it right? Am I missing something? Change, worry, risk. It's constant. It's overwhelming. That's why you need the Mineral Platform, your single destination for all your HR and compliance needs. We take away the guesswork with a clear, concise assessment of your HR and compliance needs. Thousands of workplace compliance resources that are easy to find. A smart employee handbook builder that updates policy changes as they happen. Thoughtfully curated courses to address harassment and safety, and much more. All in one place. We're a team of trusted experts in your corner, ready to provide faster, accurate guidance with challenging HR or compliance questions, and most importantly, peace of mind. And powering the platform is Mineral Intelligence, delivering personalized recommendations based on your company profile and our expertise on your HR and compliance needs. When there's something you need to know or do, we'll bring it right to your attention before you ask. By combining the best of data, technology, and human expertise, the Mineral Platform is your essential foundation to a healthier organization and a more empowered you. Navigating HR and compliance is complex, and we will make it easier for you. Mineral, HR and compliance made simple.
Thank you so much, Danielle. If you are interested in more information, especially on our 401k, the health or dental benefit solution, or the HR support center, I will drop the website information into the chat along with my contact info. Please feel free to be in touch, and we would be happy to get you anything you need. Just a reminder, today's presentation is being recorded and will be emailed to you within a week along with the PowerPoint, so be on the lookout for those. I would also like to draw your attention to the chat box. Neil and Kathleen are happy to take your questions, so get them in as they come to you via the chat section. And now it is my pleasure to introduce our speakers. Kathleen Paraguay is a highly accomplished immigration attorney and serves as co-chair of Connell Foley's Corporate Immigration and Global Mobility Practice. Prior to joining the firm, Kathleen was a partner at Dornbaum and Paraguay, where for the past 28 years, she focused her practice on immigration and nationality matters, particularly employment-based immigration and international transfers. She's been particularly successful in global mobility matters during the COVID-19 pandemic, which resulted in international travel bans imposed by the administration and embassy consular office closures that prevented the transfer to the US of professionals at all levels and all industries, which constrained US employer operations for most of this period. During the pandemic, she has performed particularly complex work to secure national interest exceptions, waivers of the travel bans and visas for high-level executives in the food supply, pharmaceutical, and construction and infrastructure industries, with noted achievements in securing entry for executives and managers responsible for COVID-19 vaccine manufacturing from US embassies and consular offices worldwide. Neil Dornbaum is co-chair of Connell Foley's Corporate Immigration and Global Mobility Practice and is recognized as one of the most active and distinguished immigration attorneys in New Jersey. Prior to joining the firm, Neil was a partner at Dornbaum and Paraguay, where he dedicated his practice to over 30 years to immigration and nationality matters, with a special emphasis on employment-based immigration. Neil writes and lectures nationally on various aspects of immigration law practice for bar associations, religious and business groups, and human resource organizations. He has served on the editorial board of several publications and has edited over 40 course books on immigration and nationality matters and chaired over 50 immigration conferences. So now, without further ado, Neil and Kathleen, take us away.
Okay. Everyone wants to be taken away by the I-9. Good morning, everyone, and thanks for joining us today. I'm Kathleen Paraguay. You heard a little bit about our backgrounds, and with my partner, Neil Dornbaum, we co-chair the Corporate Immigration and Global Mobility Group at Connell Foley. You might be thinking, why are the immigration partners reaching out to us on I-9? This is really because immigration is a subset of employment law, and all the same rules and regulations that govern employment of U.S. citizens apply equally to foreign nationals, but there are a few additions that are specific to immigration, particularly with respect to the I-9. The I-9 will arise for you every time you make a hire, and that's going to be for a U.S. citizen or a foreign national. But unlike the U.S. citizens, you're going to see the I-9 issues come up more often when you're hiring a foreign national, because each time, at time of hire, and at any change, they have to demonstrate work authorization. Again, not only at the time of hire, but at the time of any extension or amendment of their work authorization. And that would happen if there's a promotion, a relocation, there's any kind of a job change in their situation or in the corporate situation. So it's always compliance, and that is something that has to be tested and looked at each time. For foreign nationals, you'll probably see that happening every 2 to 3 years or more, depending on whether or not they apply for permanent residence. So, since the paperwork that the foreign national who's making these changes is going to supply to you with the new I-9 is immigration related, that's why you're often coming to the immigration attorney. So you can contact us at any time if you have these issues that come up, and most of our clients do. You can reach us by email, by telephone, send us what you're looking at, say, this is the document I got, is this okay? And we would be happy to recommend or to guide you in that way. It usually takes, if we see it right away, an hour or two, but in any event, it's always same day. So it's a useful tool for you, especially when you're recruiting, because you may be wondering whether or not this is someone that I really can successfully onboard. Do they have work authorization? Are they going to be able to assure and satisfy the compliance that you're required to handle when you make that hire? So that's the link vital between immigration and I-9, and the rest of it is a little bit more dry. So I'll go into the purpose of this training session with that preamble. We're intending to just give you today that basic guidance for compliance with the requirements to complete, update, and retain your I-9s for employees, whether they're U.S. citizens or non-U.S. citizens. And it's become a lot more complicated with the rise of remote work. During the pandemic, we were open, we were closed, where were these documents physically residing? So what you need to do is to be aware of some of the current guidance and handbooks that are available for you, for the employers. We've given you the websites here where you can get the current version of the handbook vital information, and unlike a lot of government forms, it's very, very helpful. It will give you examples of what you may be looking at. The current version of the I-9, and always make sure you're using the current version, is found at the next website. As far as that version is concerned, you'll see the date on the bottom, but it's critical to be using those. As prior versions are expiring, you would have to update and use the new one. Otherwise, that's a non-compliance. There's also I-9 Central, third website that we have that is additional information about the I-9. So if you're ever in a situation where you can't sleep at night and you're looking for a way to kind of pass out after a long day, you can look at additional information on I-9 Central. It's good, but it's maybe sleep-inducing. Okay, the I-9 form itself, where did it come from? In 1986, in an effort to control illegal immigration, Congress passed IRCA, the Immigration Reform and Control Act. And the theory was that if you dry up the magnetic force of jobs coming from illegal people, if you make sure everyone is legal and compliant, you can deal with the illegalities out there and not have that so much. IRCA forbids employers from knowingly hiring individuals who don't have work authorization. So the onus was on the employer. You need to make the test. Is this person someone who can legally work? Now, the question then is, just as a touch base for you, who in general can legally work? Anyone who's a U.S. citizen, they can work. They can live here, be here, stay here, work here. There are no restrictions whatsoever. They still have to do an I-9, but their I-9 would be simpler, remember, because not an immigration document. Non-citizen nationals. This is a group you'll almost never see. People born in American Samoa, Swains Island, the Federated States of Micronesia, and the Republic of the Marshall Islands. These are places that most of you probably only see in movies about World War II. You almost never will see someone from there, but people from these countries, would have their non-citizen nationals. They are authorized to work. Lawful permanent residents. Now that's a green card holder, but there are many stripes of that. People can get the green card through marriage, through parent, through employment, which is mostly what you'll see. There are asylees, there are refugees, other things. So these persons also would have the ability to work. Non-citizens authorized to work. That's people from countries you have heard of who have work authorization. That would be your H holders, TNs, F1s, Js. They would also be authorized to work. But of course, like anything else, they have to establish that to you so that you can keep the record, so that you can show that you're compliant with IRCA. So to comply with employment eligibility verification provisions of the Immigration and Nationality Act, an employer has to verify two things: identity, the person is who they say they are, and employment authorization. And this goes for anyone hired after 1986, so pretty much anyone you have on the rolls. The employer has to complete an I-9 form for each one of those employers, and the employer has to refrain from discrimination based on national origin, citizenship, or immigration status. So you can't have a blanket policy that you won't hire foreign nationals. You won't look at Muslims. You won't look at Israelis. Whatever. No policies like that. No discrimination. Completely blind as to what someone's status would be. Okay. Now, the anti-discrimination provisions prohibit 4 types of unlawful conduct: citizenship or immigration status discrimination, national origin, document abuse during the process, and retaliation. Document abuse is kind of an interesting thing. You're an abuser if you ask for too much. So you have to be careful about that. You may think you're doing the right thing to say, give me everything in your wallet. I want to see it. I'm making a copy and I'm attaching it. You want to refrain from that, and you want to always err on the side of what the instructions tell you on the I-9 form. There's a sheet that's attached to the form. There's a list of documents. You can take either one from list A, one from each from B or C, like the menu in a restaurant, and you would then be in compliance if you take those documents. Okay. You also can't retaliate against employees. That's another thing. These anti-discrimination things are enforced by our government. The Department of Justice now means business. The Civil Rights Division and the newer, it's renamed the Immigrant and Employee Rights Section, the IER. Civil penalties can be assessed per individual who is found to be discriminated against based on these fines and fees that we see here. So they start little, $375, but they go all the way up to $16,000. So you want to be careful not to engage in any discrimination. But the document abuse is really the one that's sort of troubling. Anywhere from $110 to $1,100 if there are violations there. And that could be because you thought you were doing a good job. So you want to make sure that you don't do too good a job with vetting things out. It's not your role to be a detective. It's your role to get the compliant documents, and you don't have to look behind them. If this is what they give you, this is how you complete your I-9, and you have complied with your requirement. They have 2 hotlines, which is also troubling. Employees can call and employers can call. So if an employee feels that they're being discriminated against or whatever, anonymously, they can even call an 800 number and report you. Employers who are feeling concerned can also call the 800 number and get guidance. Now, we would encourage you to call us before you call any numbers, but there is that, okay? And so if you're unsure, first line of defense, email us. Then, if we think that you should call the 800 number, we can recommend or we can help you as far as that goes. Okay. Let me see. The I-9 is nothing more than a verification tool. So if you think in terms of I'm complying, I'm verifying, and we're verifying for the government so that we make sure that no one not authorized is working, only authorized people are working, and that we're protecting ourselves because there's no knowing violation or circumventing of the process. That's really the object of doing all that. So what we want to do is to be always proactive, and proactive in terms of looking at your I-9s, because remember what we said, with most of your US citizens, you only do this once. They're there for years, you never touch it again. With your immigrant or your foreign national population, you're going to be doing this a lot. You may have more than one person in the office who's doing the I-9s, or you may have only one person. If that person makes a mistake, they tend to train someone who is also making the same mistake, and then the mistake tends to perpetuate. So it's a good practice that you look at these things probably once a year. You want to audit because you want to be mindful of those violations. If for some reason the government comes in on another matter, let's say it's a wage and hour matter, or another claim, and they want to see your records, they might look at these things too. So you want to be careful that proactively once a year, you make sure that you have someone internally or externally look at your I-9s. What we do is take a sample. We can mark for you where the areas are, and then we would do a training. And the training would tell you, this looks like it's a mistake or a misconception about how it should be completed. You want to do this going forward. We would show you a memo that you could put to the file to show that you've fixed whatever the error was after, in good faith, identifying it. And then going forward and cleaning it up as you go forward in the future. So the idea is you're verifying for the government, you're complying for yourself, you're completing the form exactly the way the government asks you to do without being a detective, and you want to make sure that you check yourself once a year. This avoids fines, make sure that everyone's legal. I mean, nobody wants to get a call in the middle of the night or on Sunday where someone says, I don't have work authorization. What do I do? They're on a big project and you have to remove them. So it's really protective, and it should be something that you understand. You don't need to know all the answers. There are resources to help you. And the first line of defense, of course, the lawyers, the 800 number. We're here to guide you through that process and keep the compliance going. So with that, I'm going to let Neil get into more of those active audit strategies that we can do, and some more detail and background on changes, especially remote work and other things that have deviled people in doing the I-9 going forward. So I'll step off camera. We're going to put Neil back on, and thank you.
Well, thank you, Kathleen, and thank you, everybody, for joining us today. When we talk about I-9s, a lot of people, and certainly a lot of companies, didn't really understand the importance of the I-9s. And a lot of that was really the government's fault, because for the first 20 years, for the first 20 years, really, from 1986 onward, there really was no enforcement. So we put in all of these really magnificent laws with the effect of granting an amnesty to individuals who were here illegally, with the effect, as Kathleen had said, to hopefully dry up the magnetic effect of the jobs and therefore limit illegal immigration coming into the United States looking for employment opportunities. But again, the government kind of shot themselves in the foot, because for those first 20 years, we had no enforcement. That really changed during the Bush administration. ICE was conducting about 400 audits per year. Under Obama, that number really increased dramatically up to about 2,500. And by 2018, under the Trump administration, we were looking at ICE audits that had doubled to over 5,000 audits per year. And in 2019, which is really the last time that the government has given us these numbers, we were looking at over 6,000 I-9 inspections that were taking place. We were looking at over 2,500 arrests resulting from I-9 inspections, and that's both administrative arrests where the person was found to be in violation of their immigration status, plus a number of criminal arrests. And criminal arrests included individuals who were using false documents and making presentations such as a false social security card. And then we were looking at the fines that the companies were paying, and that was in excess of $14 million, including judicial fines, forfeitures, and restitution. So eventually, in the last 5-10 years, companies have said, oh my goodness, this is an area of compliance that we really need to get a handle on. We need to be doing this right. Now, it's kind of a common mistake to assume that your I-9s are always fine, especially given that there's about a 60% error rate when we go in and do I-9 audits. And a lot of you say, well, we have a fantastic HR team, and we agree most of the time. And in fact, we don't even hire that many foreign nationals. But you have to be aware that you will be in non-compliance if, number one, you're not even completing the I-9 timely. And we're going to talk a little bit about what those timelines are. Number two is if you're an E-Verify employer and you're receiving a lot of non-confirmations when you are doing your E-Verify verification. That's kind of a red flag, and there is, in fact, data management that's taking place. And if they are seeing a large number of non-compliance, that is a basis for them to come out and do an audit. Also, if you were receiving the no-match letters from Social Security Administration, or one of the areas that we're seeing a lot of action in right now is if you limit hiring impermissibly to U.S. citizens. So you say, we're only looking for U.S. citizens, or if you don't have work authorization, don't apply. Well, a lot of universities, unfortunately, got nabbed recently from the Department of Justice just for that. And last is that really pesky area that Kathleen kind of touched a little bit upon, which is re-verifying documentation that's not allowed to be re-verified. So we go in a lot of times and individuals are overly ambitious. They see a green card that was expiring. They see documents that are expiring that you are not allowed to re-verify, such as identity documents. So we're going to do a little bit of training on those areas today to hopefully for you to say and feel good that these are not areas that you are having problems with. Now, the flip side of that is, and again, we're immigration attorneys, is if you don't, a lot of people say, well, if I'm employing foreign nationals, am I having additional problems that I should be aware of? And again, if you employ foreign students or temporary workers, you do need to be aware of complaints by U.S. workers arguing that the wage scales that the foreign national is getting or they're being treated differently. You have to be aware of complaints by the foreign workers as to improper deductions from their paychecks, such as, the company has furloughs or forced vacations. Some categories do not allow for that, such as the H-1 classification. If you're employing F-1 students or H-1 professionals or H-2B temporary workers or L-1 intercompany transfers, all of these categories are in fact subject to unannounced FDNS, which is the Fraud Detection and National Security, on-site inspections. And they will come in and they will check your payroll records, and they will, in some instances, also check I-9s. The purpose of FD&S is really to verify that if a company sponsors a foreign national to work, they're doing spot inspections to make sure that person is in fact working at that location where they're supposed to be and are getting paid the wage scale that they are required to pay. Because the government has a flip side where they are trying to protect wages and working conditions of US workers. Also, if you have foreign nationals who are working for you, when they go home for Thanksgiving or for Christmas, and if they have to process a visa at an American consulate overseas, it is that Department of State consular office who is re-verifying where that person is working and whether or not they're getting paid the appropriate wage scale. They are the number one reporter of potential I-9 violations if they determine that the wage scales are not appropriate in the pay stubs being presented to them at the consul. And that will unfortunately result in an I-9 audit on your premises. And last is if you are asking improper questions during your hiring or re-verification, that also will get the Department of Justice involved. So these are just a couple of common issues that will in fact be extremely costly, because we find that in most I-9 audits, companies can anticipate they're looking at fines that will average $100,000 or more. So this is an area we do want you to be aware of. And again, it should be on your compliance requirements each year. Okay, now that we have scared you, which is really not the purpose, let's talk about how we are in compliance. So let's talk about completing the I-9 form. So let's start off with some real basic questions, because this is going to give you a baseline of how good you're doing as a company. So the first question is true or false? Section 1 of the Form I-9 has to be completed within the first 3 days of employment. This is probably about the most basic question we can ask. So I'll give you a moment. Look at that question. Is this true or is this false? Section 1 of your Form I-9 has to be completed within the first 3 days of employment. Okay, if you answered false, you are correct. Now, unfortunately, many human resource professionals do believe that they have actually 3 days in which to complete that I-9. But that's not true, because that 3-day clock only refers to Section 2 of the I-9. Section 1 has to be completed either on that first day of employment or any time after you have made an offer of hire and the person has accepted it. So a lot of our companies onboard 1 week, 2 weeks, 3 weeks early to make sure that the I-9s are all in place by the time that person shows up for work on the first day of employment. But that Section 1 has to be completed by the first day of employment. Section 2 has to be, it deals with the 3-day clock. So now let's talk about our second question. So if you've done good, we're off to a good start. Number 2, while that Section 2 has to be completed within the first 3 days of employment, you don't count that first day of employment for the 3 days. Okay, true or false? Give you a moment to think about what you think the answer should be. That answer is true. Section 2 has to be completed within 3 days, but a lot of individuals don't understand that you don't count the first day. So for example, if that person starts on a Monday, you have until Thursday, close of business, to complete that I-9 form. And a lot of times that extra day can make a difference, particularly where you've not done an early onboarding and that person did not have the document that was necessary, and they have to bring it back to make sure that you can employ that person. So again, on this graph here, it kind of lays it out. So the first day of employment is a Monday. We have to have that I-9 completed by Thursday. So again, and another way to look at that, we like to be visual in what we do. An employee accepts the offer for employment. The employee completes that Section 1 no later than that first day of employment for pay. The employee then gives you the documents in the form, and you complete that Section 2 no later than the 3rd day of employment. Okay, let's try another one. These are fun. I always enjoy the visual ones. So True or false? An unsigned Social Security card is valid for I-9 verification. Give yourself a moment. True or false? I really like when we do the polling of the audience because we do always have some variation, which means we do need some training in some of our companies. And the answer to that is true. A signature on the card is not required for the card to be valid. You can accept an unsigned Social Security card as long as that card reasonably appears to be genuine and relate to the person presenting it. Why is that important? Because, as Kathleen pointed out, we do not want you to engage in an action that would be discriminatory. You have said to that person, I can't accept this Social Security card. They call up the 800 number. Guess what? We're going to be in an audit situation. Okay? Let's try one more. True or false? You must re-verify the employee's employment authorization no later than the date employment authorization expires. Now, this one's really a throwaway because, of course, you have to re-verify the employment authorization no later than the date the employment expires. But why that question is important is another point that Kathleen had kind of touched on, and that is re-verification is also never required when we're dealing with a U.S. passport that's expiring, a U.S. passport card, the I-551, which is a green card, it's just another name for it, and also List B documents. Those are identity, because that person's identity does not change. If you were given a driver's license and the driver's license expires, you are not authorized to ask them for an updated driver's license. So these are some of the little things that, again, we see as problems. And unfortunately, when the government comes in and does an audit, these are things that your company would be fined for if you are getting wrong. Okay. Let's talk about that I-9 form. Another thing that Kathleen pointed out to you is this form changes. And you must be using the current version. If you, in fact, continue to have in your drawer the old I-9s and you keep handing them out, you're not in compliance and we will face a fine representing you because you're using the wrong version of the form. So it is important to always check if the version you are using is the current version. And you also must make sure that you are always providing the individual with the current list of acceptable documents, which are, again, part of your I-9 form. Now, we have a new I-9 form. This is perfectly timed because they released the new revised I-9 form with an edition date of August 1st, 2023, and it became effective on August 1st, 2023. But they allow the employers to use the earlier version, that is the 10/21/19 version, through Halloween. So it is a horror story if you don't change those forms, because starting on November 1st, you have to use the current new version. So again, if you're on this presentation today and you are responsible for I-9s, make sure you are throwing out those old ones and you are, in fact, replacing them with the new ones, because as of November 1st, you must be using the new form. Now, the new form had a whole bunch of changes because, God forbid, the government should be consistent. And they did a lot of changes that were pretty big substantive changes. So number one, they reduced sections 1 and 2 to a single signed sheet. So it's not that 2 pages that most of us are used to, where we had page 1 on the front and then we had to flip over and deal with page 2. So now we're on a one-sided single sheet. Multiple fields were merged into fewer fields where possible. They moved that section 1 preparer translator certification to a separate standalone supplement. They moved the section 3 reverification and rehire section to a separate standalone supplement. They changed some of the wording, because we're always changing the wording to be politically correct. We removed the use of the word alien authorized to work, and we now use non-citizen authorized to work, as well as we clarified the difference between a non-citizen national and a non-citizen authorized to work. They did make it a little bit simpler to fill out these forms on tablets and on multiple devices. And they also supposedly made it easier to download. So this is the new form. If you haven't seen it, it does look a lot more compressed. And again, this is the version that you do need to be adding into your HR department so that you are in compliance. Now, it also had some additional changes. It updated the notice at the top of the I-9 to avoid some discriminatory actions. It revised the list of the acceptable documents page, and it gave some additional links, and it added a box that employers can check if they are using the alternative procedure allowing for remote examination. And we're going to spend some time and talk about the remote examination, who qualifies. They also updated the instructions. They reduced the length from 15 pages to 8. They added some key definitions. They streamlined some of the steps, and they removed the abbreviations charts, and they put them into your handbook. So if you are using Passport or you're looking for how you can abbreviate some of the things, they're now going to be in the employer handbook portion. Okay, so let's talk about the form, because most of you who are listening to us today have the responsibility of completing this form. The Section 1 Employee Information Attestation section really has not changed. So it asks for the person's last name, not so bad. Last name, you can enter it. It can be a De La Cruz, an O'Neill. It can be a multiple name, Smith Johnson. But last names, we don't normally run into too much trouble on. Same thing with first name. That's pretty straightforward. Same thing with middle name. Not too many surprises here. Those are pretty straightforward. The other names known as, they do ask you to provide any other names used, such as a maiden name, or you can put in not applicable. We don't see a whole lot of changes or mistakes where we're dealing with the address. It's pretty straightforward. Apartment number, city, town, state, zip code. Those are all pretty basic. We don't see a whole lot of mistakes on them. We do see some mistakes on the next one, which is the date of birth. Date of birth is the English version, which is month, day, year. If you are a company like a manufacturing company, let's just say, for example, you have a lot of Smiths or you have a lot of Patels. What the government is looking at is the date of birth on the employment records to make sure that the I-9 matches the employee record that they're looking at. For individuals from certain countries, they're going to invert the month and day. So you just have to be somewhat cognizant of that when you're dealing with some of your employees, that because of the naming structure from their country, they might be inversing and putting the day in front of the month as opposed to the month day. Not really a big deal. The next one is an interesting one, which is the Social Security field. Now, many of you will be surprised to learn that that is a voluntary field unless your company is an E-Verify employer. If you are an E-Verify employer, you have to get the Social Security number. If you are not an E-Verify employer, that field and the completion of that field is totally voluntary by the individual. That also goes for their email address, and that also goes for the telephone number. Both of those fields are, in fact, optional fields. And the real purpose of those fields are not for you. They're really for the government in case there is an audit and that person necessarily has, let's say, has left your employ. They will use that email address and telephone number to track the person down, to ask them any questions that they may have relating to their underlying employment. So again, you can put not applicable in those fields. Again, most people are compliant. They see it's a field. You've asked them to fill it out. They generally will fill it out. But again, it is an optional field and it is not required. We do not get fined if those fields are left blank. Okay. Now, this is the area where we usually run into problems. This is the area where the person has to designate what are they. Now, Kathleen was nice enough to go through those different 4 fields for us. A citizen of the United States is pretty straightforward. If that person's a citizen, you jump up and down. This is an easy one for us. If that person is a non-citizen national of the United States, we usually ask you to call us because we like to see one from Samoa. But again, not very many individuals here in New Jersey and the surrounding states are seeing a whole lot of individuals from our U.S. territories. Third one is that lawful permanent resident. And just be aware, when we are doing a lawful permanent resident, it asks also for you to add their alien registration number or USCIS number. And the last category is an individual who is authorized to work. And then we have to add more information. We have to write the date that they're going to expire and their eligibility documentation, or at least their coding. Now, again, this is the new form, and you will see it's a little bit more compressed, but those information has pretty much stayed the same. So it is not going to be a major difference. They've just made it a little bit different in the format that you would have been familiar with the old I-9 form. And again, when your employee is completing that, just make sure that all of the parts of the I-9 are completed by the employee in Section 1 before you start on the Section 2. And also, if any errors are found, the government says that the proper way to complete an error or to make a correction is to initial and date any corrections made. The word whiteout should never, ever, ever be used. And if you have an employee completing Section 1 with an error, it's better to just do a new I-9 and complete it properly. But if we were doing an audit and we found a mistake, then it's initial and date the correction made. But that would have to come from the individual, can't be done by the HR in Section 1. Okay, you should all be familiar with the list of acceptable documents. This has to be provided to the individual at the time of hire so that they can provide a document either from List A or one from B and C. So it's List A or a B and C. And be aware that sometimes when a person is presenting a List A document to you, it is going to be multiple documents. So if you look at item number 5, you will see it will ask for the passport, the I-94, and if you're dealing with the student, you're also having to deal with their I-20. To ensure that they are work authorized. Okay. So again, the list A, B, and C documents, most of us are familiar with it if you're doing I-9s. The big difference now is the box for additional information looks a little bit different, and there is a checkoff box in there if you're doing the remote I-9s. And again, we're going to talk about the remote I-9s today because that's really the new and exciting area. Again, when we're dealing with a List A document, be aware it cannot be an expired document. And you do need to issue who issued the document, what agency, so like Department of State, if we're dealing with a passport, and you need to capture the document number. Also, we like best practice, which is to make a copy of the document being presented to you. That had been a question, do you in fact make a copy? The answer is we find that we save a company a lot of money when we make the copy. And the reason is if there was a mistake, something wasn't filled out properly, we generally can make those corrections if we have the copy attached to the I-9. If there is no copy, there's no way to make that correction, and you're more likely to have a higher fine in that scenario. So best practices right now is making a copy of the documentation being presented to you. If it is two-sided, the government asks you to make copies of both sides of the document. Okay. If they don't bring that List A document or that multiple combination of List A documents, then you need a B and C. Again, why? A List A proves both identity and employment eligibility. A List B only proves identity. List C proves the work authorization. So again, it is the choice of the individual. Companies can never, ever, ever ask for a specific document. You can't say, I'm a permanent resident, please bring me your green card. You do that, you're going to be in trouble. So it is always the foreign nationals option as to what, or the U.S. citizen, what document is being presented to you. Generally speaking, if you are doing I-9s, you know that from a List B and C standpoint, 90% of the time you are being given a driver's license for the List B, and you're being given the Social Security card that is unrestricted for List C. And if you don't understand what the difference between the restricted and unrestricted is, some Social Security cards have an additional restriction that says not valid without USCIS authorization or work authorization. If it has that restriction, it's not an acceptable List C document for your purposes. Now, if you do not know what document and you are not working with legal counsel, the I-9 booklet is phenomenal because it gives you pictures of every document that is acceptable with circles around it helping you. So I see we have a bunch of questions coming in, so I will try, hopefully I'll talk fast and hopefully get to most of those to answer them. So again, the documents will, if you have questions on documents, the I-9 handbook is very good, has lots of help for you. And unfortunately, it is a 180-page document to print out, and it does put you to sleep at night, but it actually is well written. And generally speaking, we're on speed dial for most of our HR departments, and we will always point you to where in the document that that booklet, most of the time your answer can be found. Okay. The employer authorized representative in section 2. This section, which is the one that a lot of companies were getting wrong before, this will look familiar to you, that you have to put in the employee's first day of employment. It was a separate line, and then you had to put your signature, the date, your title, the name of the employer, the business organization, the address, the city, state, zip code. That changed a little bit on the new form, because if you look down towards the bottom, you'll see that they took out that front line and they moved it over to the side. So you still have to put in that first day of employment. And the other portion still has stayed pretty much the same. But again, everything now has been condensed onto that one page. And for those of you who are dealing with individuals who are speaking in a foreign language, or you were helping them to fill out the form, therefore you were a preparer, this section was on the old form, has now been moved to a separate addendum. So you will see as a supplement A what you were used to seeing as the translator or preparer section. That now has become a supplement. That also happened for these reverification. If you have a choice. You can either use the Section 3 reverification for individuals who you are re-verifying or rehiring within a certain period of time. Or you could have just done a new I-9. The choice is still yours, but now if you are familiar with the reverification section, we have now gotten a supplement B. So now we have supplement A and supplement B. The information is still pretty much the same. So we have some common questions. And I'd just like to quickly do those to eliminate some of them. So can I fire an employee who fails to produce the required documents within the 3 business days of their start? That's really a tricky thing because you're hiring people all across the board. The managers really needed this person. The company needs this person. And it's a problem where a person comes in and doesn't have the appropriate documentation. Now, as we pointed out in the beginning, hopefully you're getting support from upper management because this is a compliance issue. And we're talking about fairly substantial fines if, in fact, an I-9 audit has to take place. So hopefully you have some buy-in, and the answer is if a person does not present those documents within those 3 business days, and remember, we don't count the first day, so you've got that hopefully extra 1 day, you must terminate that individual, otherwise they're going to be working without proper authorization. Another area that we get a lot is, can I accept a photocopy of a document presented by an employee? And the answer is generally no. The employee has to present an original document. The only exception is they can present a certified copy of a birth certificate. The other exception is if we're doing the remote review of an I-9, and again, that's limited. Another one we get a lot of is my employee presented 2 documents to me to complete the I-9, and each was containing a different last name. So one document matches the name entered in Section 1, But the employee said, look, I just got married. I've changed my last name. I haven't changed my other documents. And the question we get a lot is, can I accept the document with a different name? And the answer here is yes, you can. Actually, the government applies some common sense rules in this area, and you can accept the document with a different name than the name entered in the Section 1, provided that you resolve the question of whether the document reasonably relates to that individual. Now, in some cases, we generally recommend that you attach a brief memo or a brief statement stating why there is a discrepancy. The individual provided us with their marriage certificate and advised that they had just recently married, and I'm satisfied that this is the same person. So that isn't acceptable. Compound names. Can you accept a document with a compound name? Again, DHS does not require employees to use any kind of specific naming standard in the I-9. If they enter more than one name but presents a document that contains only one of the last names, but you are reasonably satisfied that it is the genuine and relates to that employee, that is also acceptable. The other one that we see a lot of is where the document presented is spelled slightly different than the name entered in Section 1. And sometimes that has to just do with the way some countries do their naming, and others you'll see some slight variations. The good news is again, the government has said if the document contains a slight spelling variation and the employee has a reasonable explanation for the variation, you can in fact accept that document. So those are some kind of unusual ones, and it's good to know that they've put that into writing and have in fact confirmed that. Best practices also is if you are leaving an area blank, it is good to put in the NA for the not applicable. It's just a better practice. They had recommended that as a course of action. They kind of pulled back a little bit on that, but we still recommend that if, in fact, you are going to leave an empty area, to use the NA on the form. Employers can only correct errors in Section 2 and 3. Remember that Section 1 is the employees, only they can initial and date the changes. And again, if in fact you're doing an audit or a review, or you've caught a mistake, draw a line through the incorrect information, enter the correct information, initial and date the correction. If you're doing multiple corrections, you're probably best to reach out to your legal counsel to determine whether or not you're going to be making those corrections on the form, or whether or not you're going to need to use a new form, the updated form, because the rules are you have to use updated forms in certain instances. But the big key here is don't conceal changes, and don't use correction fluid on your things. It is surprising how many mistakes can be made on an I-9 form. It was a 2-page basic form, and as I indicated, about a 60% error rate. So you can see on this screen here just how many mistakes can be made in Section 1 alone. And unfortunately, when we do I-9s, what we do is we have multicolored Post-it notes, and we basically use the different colors for the different kinds of mistakes where they are. And unfortunately, I would say that most of our companies are surprised with the rainbow that they receive back from our office on how many corrections are necessary. So don't feel that that you are alone. If you in fact are doing your proper audits each year and are finding a large number of mistakes, it just is the nature of the beast with dealing with I-9s. But the goal here again is compliance, and the goal here is to correct as many as possible. And in the Section 2 and 3, again, lots and lots of potential mistakes can be made. A lot of them have to do with not putting in acceptable B and C documents, not completing the List A documents properly, not putting in the title properly, the issuing authority, not filling out the date that the person started work, not putting in the date the person reviewed it. Again, a lot of them can be corrected if, in fact, we have copies of documents where the mistakes are being made on. So again, the copying of the document from List A, B, and C is really a good and best practice for you. Some general tips. Make sure that the information is clear and can be read. It is not good to have an HR rep whose handwriting you cannot read, such as mine. My staff somehow has figured out how to interpret my handwriting, but I would not be a good person to help complete an I-9 form because nobody can read what I write. The date entered in the section 2, as the date the individual begins employment, should match the date in your payroll records. Why? Because when the I-9 audit is done by either ICE or from Wage and Hour, the first thing we have to provide is your payroll records and all the I-9s, so they can then run them to make sure that there is an I-9 for each employee listed. If you're doing hole punches, staples, make sure they don't go through the information. We've had problems with that. And copies should always be, or the abbreviation should be widely understood. And again, if you're going to use abbreviations, it's fine, but make sure you go into the employer handbook and see what abbreviations they are recommending and accepting from you. And also, you should be using the English version. There is a Spanish version, but it is only approved for use in Puerto Rico. Now, some of the oddities to be aware of in dealing with your I-9s is the Social Security card does not need to be signed. We get that. The Social Security isn't signed. I get that every time I go out and use my credit card. Why I have to sign it? Now, if the person steals my credit card, they know what my signature looks like, but the Social Security card does not need to be signed. The Social Security card cannot be laminated. Another weird thing. Why? I don't know. Can't be laminated. It does not have to have a current last name on it. So again, if the person is married or changed, those are all good. Passports cannot be expired. Even though it is the same person, unfortunately, documents have to be valid. Now, the big thing that has changed is the alternative procedure for document examination. Under this, employers or their authorized representatives, generally speaking, must physically examine each original document from the employee, unless we're now going to be able to use the alternative procedure to determine that that document really is genuine and relates to the person who's presenting it. And generally, representatives in the past have had to examine these original documents in the physical presence of the employee presenting them. And the government says to us, look, we want you to physically examine these documents because it allows you to determine if they appear to be genuine and they relate to that person. And by being able to physically examine the original, you can touch it, you can feel the stock, you can see if they have holograms, they have microprinting. So there is a reason why they want you, the individual, to present an original document to you. Now, the alternative procedure, which allows that individual to provide you with a copy and then for you to have a video conference with that person, is currently only available if you are an E-Verify employer. Now, if you are not an E-Verify employer, there are pros and cons to becoming an E-Verify employer. And what E-Verify is, it's the system layered on top of the I-9 that allows you to put in information electronically, and that E-Verify system is more robust because it will now check the Social Security Administration, Motor Vehicle Administration, and Immigration for verification of the underlying documentation being presented to you. The bad news of E-Verify is there is a full data center who monitors error rates. So, depending on your industry, there is a plus and a minus. The other plus to being an E-Verify employer is STEM. If you are using or wish to use students who are graduating from U.S. universities, individuals who are in the science, technology, engineering, or math field, in addition to 1 year of practical training that they are entitled to at the completion of their course of studies, STEM individuals working for an E-Verify employer can get an additional 2 years. That means they can get 3 years, which is very, very, very important, because if you like that individual and you want to extend an offer for them to work, you're going to have to change them in most instances from that F1 practical training to an H-1B. The H-1B being the most common work visa for professionals in the United States. The problem, we don't have enough work visas to give out to each person seeking it each year. And in fact, we only have 85,000 H-1Bs available each year, of which 20,000 are dedicated only to individuals graduating from U.S. master's and PhD programs. So it's actually a 65,000 plus some spillover from unused numbers from the year before. But we had almost 700,000 people apply for those 85,000 slots. So what does that mean? If you're an employer, you want to retain that student, you may have to file more than 1 year to hopefully get selected. So by having STEM, they can get 3 bites at the apple instead of 1 bite at the apple. And that is valuable to you as a company who wishes to retain that individual's services. Okay. So if you are a qualified employer, i.e., you are an E-Verify employer, you can choose to use this alternative procedure where you must retain a clear and legible copy of all documents presented by the employee seeking to establish their identity and employment under the alternative procedure. And these retained documents allow DHS to assess the documents that were presented and remotely examined by the employer, and to confirm that you are not engaging in any discriminatory practice. So what does this practice entail? Well, within 3 business days of the employee's first day of employment or before, meaning again, you've extended an offer, they've accepted it, you can do your I-9 before they start work. You can use this procedure. You are required to examine the copy front and back if the document is two-sided of the I-9 document to ensure that it is genuine, and then you must conduct a live video interaction with the individual who has presented the documents to ensure that the documentation reasonably appears to be genuine and related to the individual. So basically what you're doing is you're asking that employee to transmit a copy of the documents to you as step 1, and then present the same documents during the live video interaction. And then you will indicate on your I-9 by completing the corresponding box that an alternative procedure was used to examine the documentation. That's the new add-on in the additional information. And then you have to retain, consistent with your normal regulations, a clear copy of the document front and back. And if there is an audit, the government is going to look at that to see what procedure you in fact used. So some of the questions that then came out of this is, can a qualified employer continue to examine documents physically instead of using the alternative procedure? So the answer is, of course, yes. You can use the alternative procedure, but that's optional. Nothing has changed in allowing you to physically examine documents for your I-9. And can you offer alternative procedures to only some employees? Well, remember that word discrimination. So a qualified employer doesn't need to use the alternative procedure, but if they choose to, you have to be consistent for all employees at that particular site. Now, if you're a qualified employer, you can offer the alternative procedure for remote hires and continue to apply a physical examination to all employees who are working on site. So you can do some kind of hybrid capacity as long as you're not adapting a practice for discriminatory practices. So again, these are more difficult questions that generally you want to address with your legal counsel to make sure that you are not only meeting the I-9 requirement, but you're also making sure you're not engaging in any kind of discriminatory actions. One of the other areas that are going to be difficult for you is the timing on the COVID flexibilities. We had a whole bunch of different flexibilities that were introduced for remote individuals and for companies that were not having people on premises during the COVID period of time. I've put a slide in on that. If that applies to you and you have questions relating to that period of time, it is probably better to reach out to us to discuss, because they are somewhat complicated as to what you can and cannot do as a company. With the time we have left, I see we have lots of questions. So let me just tell you, if in fact you are going to have an inspection, normally what will happen is officers will appear and they will issue what is called a notice of inspection. And they will tell you that you have 3 days in which to provide them with your I-9s, or if you'd like, you can give them to us today. If you are represented by legal counsel, even if you're not, you should always decline their welcome option to give your documents immediately. You should reach out to your legal counsel. We always want to make sure we have copies. We want to review what the government is going to receive. And generally speaking, most of the time we can tell them we need an extra week or two before we can drop them off at your office, and we've never really had a problem with that. But the way that the investigation goes is a notice of inspection is issued. The government will inspect your I-9 forms. They will come back to you and tell you, we believe that some of these documents are suspect, or we have a notice of discrepancies. These Social Security numbers are not matching. You then will basically go into a review where you can make corrections to substantive violations. Technical violations, they break them down into 2 different fields, and then you will either get a warning notice or a notice of intent to fine. And after a notice of intent to fine, you can either reach a settlement, or you can then elevate that to OCAHO for an actual hearing on the merits of the determination. There are a number of procedures as to how to store your files that you should be aware of. Also, retention. Files must be stored for 3 years after the date you hire the employee, or 1 year after the date you terminate, whichever is later. So to identify that date, that's important, because you want to get out any old I-9s that you don't want to have during the course of an inspection. So if we have someone like John Smith was hired on November 1st, and he was terminated on July 5th of 2021. November 1st plus 3 years would get us to November 1st, 2023. July 5th plus 1 year would only have taken us to July 5th, 2022. You have to have retained that document through November 1st, 2023, the latter date. Okay. Again, as Kathleen indicated, there is more information at I-9 Central. And again, we do refer you back to the manual. Again, as Kathleen said, it is good to have an internal I-9 audit. It is also good to have an external, because the person who makes the mistake continues to train with the mistake. So having an external audit is really good practice. And for your companies, you can tell them the benefit of that external audit is all of the following type of things. I'd like to just spend a few minutes with the questions that we have, with the time that we have left, because we did get a bunch of questions in. Let's see. Yes, our question about when they ask for both sides of a document, when it says it's two-sided, what's an example of this? Well, pretty much most documents are pretty straightforward for you just turn it over, and if there's information on the back they want to see, make sure you're making a copy. So our thinking is every document is two-sided, even if there's a blank side. You can't make a mistake if you copy a blank side. That's the easy answer. For a passport, is it only the front of the passport that's required? Normally, again, for the passport, what they're looking for is the identification page, which tells you the nationality of the individual. So if we're dealing with a U.S. citizen, it's usually the ID page that we are really looking for. But again, you can't make a mistake if you're making a full copy. Do we obtain a copy of a blank side of a passport book? Again, it's common sense. I really have never been in a situation where they fine me for anything more than just the identification page on the passport. But if it's a Social Security card, if it's a birth certificate, if it's an Indian document, they're looking for both sides to be copied. We have an employee starting on 10/23/23. Her employment authorization document expires on 10/24/23. Is this acceptable? That's a toughie. The answer is yes. If the individual has a valid employment authorization card and is work authorized, they are entitled to employment. Now, the big problem you have is they're going to have to provide you with additional documentation to show that they are continuing and are authorized to work beyond that date. Now, be aware, if we're dealing with an employee who is working under an employment authorization card, let's say from the government, you have to be aware there are 33 different classifications, and about a quarter of them or more have automatic extensions. So it is very important that you are spending some time either again with legal counsel or the individual or with your I-9 handbook or with the USCIS website to determine the coding on the employment authorization document and any receipt that they are able to provide to you to determine whether there is an automatic extension. It gets more complicated where you're dealing with TPS, temporary protected status, political asylees, refugees. Those individuals also, many times the government automatically extends. So that might be by regulation. So again, if you have a question in those areas, those are probably good ones to reach out to your legal counsel. If we have previously re-verified a green card, how can we amend this? If we've previously re-verified, meaning that you shouldn't have done it. Well, yeah, we come upon that quite a bit. Unfortunately, you can't really do much at this point. Normally what we do is we put a note into the file, the I-9s, which basically say that an internal or external audit has revealed that we were making an error in how we were re-verifying certain information. We've received additional training as of this date. And going forward, that training has indicated that we will not be engaging in an activity that was previously now determined to be an error. So that's probably the best you're going to do. It doesn't really vary. You can't, there's not a way to correct that type of error. You can only correct it going forward. We have a distribution center in Georgia. We complete new I-9s virtually. Is it okay to receive the IDs via email from the ops manager who is on site? What would be the correct process? If I'm understanding the question correctly, if we complete and hire I-9 virtually, is it okay to receive the IDs via email from the ops manager? Well, why don't you just have the ops manager complete the I-9? Therefore, you're doing a physical inspection, and that manager is acting as your agent or as your employee for purposes of completion of the I-9. That one, you may want to follow up with us to clarify it further. Okay, let me just see. I see a couple of others. How much time do we have? We have a few minutes, so I guess unless I'm told differently, maybe I'll let me just keep going down. Do I need to complete an I-9 for independent contractors and their employees? The answer there is no. For example, let's say if you contract with a construction company to perform renovations on your building, you don't have to complete an I-9 for that company's employees. They're responsible for that because they are independent contractors. So that construction company would be responsible for completing the I-9 for its own employees. But remember, you can't use a contract or a subcontract or an exchange to obtain labor of services for an employee who is known to be unauthorized. So if that were to come to your attention, then you would be in a potential fine situation. What happens if I properly complete and retain an I-9 and DHS discovers that my employee is not authorized to work? That's a very interesting question. So if I understand the question correctly, what that is contemplating is during the course of an audit by either ICE or Wage and Hour, they've come back and said this individual's Social Security card or documentation shows this person is not authorized to work. Now, what has happened in that, we've actually had that happen a lot with our manufacturing companies. And that is, the individual presented to them a green card that was later determined not to be a valid green card, or they provided a social security card and a driver's license, and it was found that the social security card was not valid. Well, the good news is the employer in those situations had a good faith defense against the imposition of employer sanctioned penalties, because the government has to prove it's knowing. That is, that either the HR or the company itself was on notice that these documents were not valid. As long as they appeared to be genuine on their face, the company was absolved from hiring an individual who was later determined to have presented a document that was not valid to them for proof of work eligibility and identity. So in that particular case, the company would be we'd be able to defeat any kind of potential fine in that scenario, based on the fact that the company acted in good faith and did not have knowledge of the underlying. Now, that's different if the company sent the person out to Newark and said, on Ferry Street at this building, you can pick up a fake green card and then come back and then we'll employ you. That would be a bad thing to do, but that's not usually the case. Well, this is a pretty basic question. Can I ask an employee to show a specific document when completing Form I-9? Well, that one I'm assuming you're new to I-9s. And the simple answer is resounding no. Please do not engage in an activity where you are asking any individual to provide you with a specific document. That is the quickest way for you to get into trouble as an employer, because you cannot. That is clearly a discriminatory practice. So we have. When can employees present receipts for documents in place of an actual document? The receipt rule is really that's another good question. It's an area that most of our HRs do show problems with. The receipt rule, I find is probably one of the most difficult areas for us to deal with, because it's really designed to cover situations in which an employee is authorized to work at the time of original hire, or reverification, but doesn't have the actual document listed in the list of acceptable documents. And there are specific rules as to what receipts you can accept. So you can't accept a receipt showing that the employee has applied for initial grant of employment authorization. That's what we see a lot, and or an employment authorization document, the EAD card. What I would refer you to is in the employer manual, look at section 4.4, which is listed as acceptable receipts, and that has a whole list of what documents would be acceptable in that scenario. Let me just, I have one other question. It says, my employee's EAD card expired, and now they want to show me their social security card. Do I need to see the current DHS document? That also is an excellent question, because it kind of highlights what we were talking about. The answer there is no. During a reverification, you have to allow that employee to choose any document that they want to present. So it can be either from list A or list C, because remember, you don't re-verify list B documents. That driver's license I had just had it about a month ago, where a company was so proud they had re-verified all the driver's licenses. And I felt so bad telling them that was a terrible situation that they had put themselves into, because you can't re-verify that list B document. So again, if an employee has presented to you an unrestricted social security card, they don't also need to present to you an additional DHS document. So if they had previously used an EAD document, and now they're presenting to you an unrestricted social security card because now they've obtained their permanent residence and they'd rather just provide you with the additional document, that shows their ability to work, the unrestricted social security. That's accept. You don't need to get the same document that they previously presented to you. So I think we've covered a lot of topics. I understand they're going to provide to you a copy of the training, PowerPoint today. As Kathleen indicated, our contact information is available to you on the PowerPoint. We welcome the opportunity. Both Kathleen and I are both on speed dial every day for HR representatives throughout the United States. This is a complicated area. It is an area that you who have taken the time to participate today needs to make sure you have educated your company as to the critical importance of this as a compliance requirement for the company. Again, a lot of companies really never hit their blip screen because there was very little enforcement. But times are changing, and it is one of those compliance areas that should be on that checklist. And as we approach Christmas and the new year and all those wonderful things that you and HR are required to do, this should just be one more thing on your checklist of things that you want to make sure that the company is aware of and that you are in full compliance. So with that, I thank everybody for all of their diligence and giving me that extra time, because I think we ran a little bit late, didn't give you the opportunities, but we do appreciate that, both Kathleen and myself. So I'm going to turn it back over.
Thank you. That was fantastic. And unfortunately, that is all the time we have for questions. Don't forget that you will all be receiving a recording of today's presentation and the PowerPoint presentation via email within a week. Our next HR program will be in person on November 8th, so watch your incoming email for more information on that. That HR program will be focused on HR employee handbooks and will be presented by guest speaker Michael Shadiak of Connell Foley, one of Kathleen and Neil's colleagues. I'll drop the link into the chat in case you'd like to register for that. And thank you so much for joining us. I am Kate Conroy from NJBIA, and on behalf of Neil Dornbaum and Kathleen Paraguay of Connell Foley, have a great rest of your morning. Thanks so much.